Welcome to the Spiggle Law Firm podcast, where we help people who've been fired or afraid that they might be. We also discuss cutting edge legal issues in the news. I'm thrilled today to be joined by an attorney in my office, Ross Fodera. Welcome, Ross. Appreciate you being here with us today.
Thanks, Tom. Thanks for having me.
All right. So what are we going to be talking about?
So today there was an interesting case of plaintiff Javon Wade. He was a former insurance agent with AAA, the towing company and such, over in Florida. So essentially, in February 2022, he was on the phone with a customer when his children began arguing in the background. And the female customer reported him to AAA, believing that there was violent yelling in the background since she was unaware that it was children. And as a result, he was suspended without pay due to the complaint with no evidence, and he claims that that was because of gender discrimination. So recently, last month, as everyone knows, there was the big solar eclipse that kind of took over the news in everyone's free time. And he missed his April 8th deposition as he failed to communicate that he'd be going to Arkansas to watch the solar eclipse. And as a result of that, AAA's attorneys are essentially asking for the entire case to be dismissed, to get attorney's fees, and specifically for the case to be thrown out with prejudice, essentially barring him from any other chance of getting into court with his claims.
Could you tell from the opinion, is he represented by counsel?
Yes. At the deposition, the AAA attorneys waited about 13 minutes until after they were scheduled to begin to reach out to Mr. Wade's attorney, who then reached out to Mr. Wade, and then he eventually called back the AAA attorneys to let them know that he was in Arkansas.
Yeah, it's a fascinating story, and I think a good opportunity to talk to folks about depositions generally. Depositions are, as you well know, Ross, these occur after you've already filed your complaint. So depositions don't happen when you're doing the informal back and forth or after you've sent a demand letter or even at the EEOC if you have to file your case there. And they are a substantial part of the case. And it is, while they don't happen in court, they're not before a judge, it is as if you are in court. So you have a court reporter there, you're sworn in, the other side's attorney's there. If you're represented by counsel, your attorneys are there, and the deposition is transcribed. And that transcription, and sometimes it's videotaped as well. And those videotapes and the transcription can be used at trial just as if you were testifying there. So it's not something that you just easily skip out on. The other side has to give a deposition notice, has to tell how it's going to be recorded. They have to hire the court reporter or the videographer if they're doing the video, which is not inexpensive. So you can't this is not just like some kind of a haircut appointment or something you can kind of skip out on easily, even though I can certainly understand. And let me also say, sympathetic to somebody who's had doing a Zoom call and had noise in the background. I think we can all relate to that. So sorry that happened to him. Anybody who has kids or a dog or any kind of interruptions has experienced that. But in any event, you can't just skip out on them easily like that.
Mm-hmm. Yeah, and as a result of this, Mr. Wade's attorney has already agreed to pay for AAA's attorney's travel expenses, the cost of the court reporter, and to reset the deposition for 2 weeks.
Yeah, and that would have been the better option for him if he'd just gone through his attorney, because that happens all the time. You can reschedule depositions, which is not an uncommon thing to happen. And your attorney just calls the other attorney and you pick another time to arrange to get everybody there. So that would have been the better course of action from him. So if you've got a deposition, and those folks who want to look at it some more, of course, there's tons of stuff on YouTube and social media about it, but you can look at the Federal Rules of Civil Procedure, Rule 30. Talks about the use of oral depositions, and there are other federal rules that kind of describe how these work and lay it out. But they are essentially like courtroom light. You're not in the courtroom, but you're the transcript of the deposition. The video can be used in the court, and you're under oath, right? You're under oath just as if you are in court. So they are a big deal, and not to be just skipped out on, no matter what your reason might be.
Yeah, and in a broader sense, it kind of shows how important, discovery and other litigation-related events are, and how important it is for plaintiffs to kind of clearly communicate with their attorney.
Yeah, it's a great point. There's a lot of, you hire an attorney to be able to help you shepherd the case through court, but he or she is only as good as your ability to cooperate with your attorney to get him or her the information they need timely to show up to your depositions. It's just a bad idea to not show up for depositions, to be late for mediations. I've never had somebody skip out on a deposition. I have had a client be late to a mediation one time with a federal judge. And boy, let me tell you, that was uncomfortable for me because I'm sitting there with opposing counsel and the judge is fuming. And my client was, had trouble finding parking and was just late. We ended up getting a good result in that case, but it didn't start off the mediation with a bang in our favor, let's say. So it's a great point. You need to cooperate with your attorney, try to be timely for these events. Judges in particular really do not like it when you're late for mediations or hearings or anything that they're involved in. And of course, in this case, skipping out on a deposition can be costly. Now, I know they're asking for the case to be dismissed. Do you have any thoughts on whether or not that's going to happen?
I highly doubt it, hopefully, since he won't really have another chance to get his day in court, essentially. Especially once you hit the discovery phase, you've kind of already gotten past your, motion to dismiss, summary judgment, and all the other stages where it could have been thrown out already if the case at least wasn't good enough to go in front of a jury.
Yeah. Well, you normally would have deposition before summary judgment, but in any event, like you're absolutely right. Like I think that's probably, I understand why the other side is asking for it, but the court's very unlikely to kick the whole case out because that's just a pretty harsh penalty. That can happen, but usually only if the behavior by one of the parties is really egregious and ongoing. So a one-time screw up like this, I think the court will probably say, yeah, and the other side's already offered, you've got to pay for their travel expenses, you got to pay for the court reporter, which is not, that's going to be several $1,000s at the very least. So that's not nothing, but I don't think the court is going to take the draconian action of kicking the case out. I think you're right about that.
And I think it's also a good lesson in how aggressive employers' attorneys can be in kind of pouncing on the mistakes of plaintiffs. I'm sure AAA's attorneys are in a much better position to kind of see these mistakes by the plaintiff and pounce on them, or something that AAA wouldn't make the mistake in the first place. And
absolutely.
Balance of power.
Yeah, absolutely. Defense counsel often where they're going to take advantage of, they're going to go right to DEFCON 4 or 5, whichever one is the top. If you have a slip up like that. Courts are used to that and they usually moderate them, but it's a good point. You don't want to, every case has strengths and weaknesses that you've got to work within those confines. You don't want to have a foot fault where, you're creating an opportunity for opposing counsel to, damage your case or at least make your life miserable for a little bit from something that could be avoided like this. So show up to your depositions, listen to your attorney, be there on time, give them documents that they need in a timely fashion. This is your case. And it only hurts you if you aren't following up with your attorney and requesting, and his or her requests and making sure that you've got those things on your calendar. I forgot about this, but it just occurred to me. I did have one case one time where we represented the defendant in that case, as was years ago, and he was the employee. And I was in the car and I got called by the other side and they're like, "Hey, we're here for the deposition. Like, where are you guys?" And I had another attorney on the case and I was like, heart in my throat sort of thing. And so they were like, well, we'll wait for you to show up. And then as it turns out, we didn't get that because the other side has to send you notice of the deposition, right? It's a formal document and they've got to formally notify you. They're not required to pick out a date with your attorney. That's usually good practice, is to try to find a date that is agreeable. But the other attorney does not have to. They can just pick a date and send the notice of deposition. And in this instance, it turns out the other side sent it to the wrong address. So this was before the days of, we had email, but people did things by hard copy. And so we just never got it. So there were no penalties in that case. We just rescheduled the deposition. But that's another example of where, it was definitely uncomfortable to get that call, or maybe it was the email, I remember, in my car and have to pull over the side of the road and call co-counsel and be like, what happened? What happened to you? So they're not to be trifled with. Well, thank you for joining us for this episode of the Spiggle Law Firm podcast. If you'd like more information like this, you can find us at the careerrocket.io, which you can send us, go there, give us your email, and you will once a week at no charge to you receive an email that's chock full of great legal information and also other information from career professionals and others to help you keep your career on an upward trajectory no matter where you are at work. So feel free to do that. You can always check us out on our website, spigglelaw.com, for more great employment law information. Thanks so much, and until next time.